Hello and welcome to Different Perspectives. I am Paul Ndiho. Uganda's parliament passed a controversial bill giving military courts the power to try civilians, defying a Supreme Court ruling that banned the practice earlier this year. Opposition lawmakers are furious. They say this law violates Article 92 of the Constitution, prohibits the parliament from overturning court decisions. Legal experts and rights groups warn that this is a direct attack on judicial independence and a red flag ahead of the 2026 elections. The bill allows civilians to be court-martialed if their actions are tied to military operations. It also requires judges in these tribunals to have legal training, but critics say this is just lipstick on a dangerous policy. President Yoweri Museveni, who has been in power since 1986, is expected to sign this into law. His son, General Muhoozi Kainerugaba, has backed it, fueling concerns that this is about silencing dissent, not justice. For more analysis on this controversial bill giving military courts the power to try civilians, I'm joined by Dr. Sarah Birete, a Ugandan lawyer, founding partner, and executive director for the Center for Constitutional Governance, a Ugandan constitutional watchdog non-governmental organization. Dr. Birete, welcome to Different Perspectives.
Thank you, Paul, and greetings.
You are a lawyer, you follow this very closely. It's something that you've worked on for a very long time. Uh, Tell us what this means, the passage of this bill. Tell us what that means to ordinary Ugandans, to the country at large.
Sad day for Ugandans, given the celebration that went on countrywide after the Supreme Court ruling nullifying provisions for the trial of civilians in military courts, and to see the same being reenacted just after a few months of the Supreme Court decision, precisely 4 months, is really saddening for Ugandans. It dampens the mood, even when we knew we had a struggling rule of law situation, scored at 42% globally. But the reenactment of provisions for the trial of civilians in military courts is extremely depressing.
Does this mean that there is a power struggle between those arms of government?
Yes, the president convened the NRM caucus a day before the passing of the law, and he told them that he wanted that bill passed without any alterations. According to sources, he also told them that if they cannot do his work, he can get other people to do his work. So the MPs were threatened. We are going into elections in a few months. That was threatening to them coming from their chairperson. But on top of that, the military was, surrounded parliament. The black vans that are known for torture of people after abductions were present at court. The military was present on the stairs of parliament, both in military fatigues and in plain clothes. So the situation was extremely tense and intimidating. And the MPs knew that they were being watched, especially those within the NRM.
What does this mean for the rule of law in Uganda? It's a country that prides itself, one of those countries that abides by the rule of law. But here we are seeing some extreme examples of what that can also do to the Ugandan constitution.
The rule of law is defined by two pillars. One first pillar is equality before the law, and the second pillar is a right to a fair trial. The Supreme Court decision expounded in detail to the extent to which the military courts are unable to guarantee a fair trial because of lack of independence, impartiality, but also pointed out to the competence elements. The Supreme Court also did state that even if soldiers who are lawyers in the military were to be appointed judges, they would lack impartiality. because of the military nature of command and control and reporting mechanisms. And indeed, the law has created a section for the Department of Military Courts and with a disciplinary mechanism, meaning that judges will be subject to disciplinary mechanism under this Department of Courts. So they cannot say that they have the same safeguards to dispense justice without fear or favor as required under Chapter 9 of our Constitution and specifically under Article 128(1) of the Constitution of Uganda. They don't have.
Your perspective as a lawyer, what does this mean for people like you who look up to these institutions of justice as a means to save the country? There are a lot of critics who said that this bill, once signed into law by the president, is specifically targeting opposition leaders who have been critical to the NRM government. Your thoughts on that?
Yes, it's true. And previously, we have seen a situation where military courts were dominated by two characters of people. The first character are members of the political opposition, and the second dominant character are the cattle rustlers from Karamoja. So the political opposition specifically are usually bundled in these courts towards the election time. And it's important to note that Uganda is preparing for elections a few months from now. So maybe the rushed manner of having that bill in place is part of preparation for elections on the part of President Museveni and his team.
The Ugandan constitution, specifically Article 92, says it prohibits Parliament from overturning court decisions. In this particular case, legal experts, rights groups warn that this is a direct attack on the judicial independence in Uganda. Your thoughts?
Obviously, the bill, especially clauses regarding reenactment of provisions on trial of civilians in military courts, is retrospective, is prohibited under the Constitution. And Article 92 is to the extent that you cannot reenact laws aimed at defeating the purpose of a court decision. The court nullified trial of civilians in the military courts and also created an exception that for any trial in future after professionalizing courts, it should be in exceptional circumstances. When you look at our situation, the only exceptional circumstance that would warranty trial of civilians in military courts, given that all offenses captured in the UPDF bill are already taken care of in the Penal Code Act of Uganda, it should have been exceptional circumstance of a situation of war where there is inability to access ordinary courts. That should be the only justification in our case.
Dr. Virete, I'm not a lawyer, but from the little that I know, if a bill like this is passed into law, does it mean that it's going to be retroactive? It goes back to all those cases that are pending that were supposed to be tried in military courts to be tried, or it starts from once the law is enacted, or rather once the law is signed into law, the bill is signed into law going forward. Does it go back, or it just starts from now going forward?
Ideally, it should start from now going forward because Article 28(12) of our Constitution provides that for any offense to qualify as a crime, there should be an existing law prescribing the offense and the punishment. So when this law is enacted on 20th of May 2025, you cannot apply it to offenses which were committed before that day. That is retrospective application, which is null and void. But given that this is military kangaroo courts that do not provide safeguards for a right to a fair trial, as well as other safeguards for fundamental rights and freedoms, it wouldn't be surprising for Mr. Museveni and the army to do such a things that violate the constitution, because the law itself violates the constitution.
So does this mean that for opposition leaders like Dr. Chiza Besigye and all the other opposition leaders who have been put in military courts before, until there was an uprising or an uproar suggesting that they shouldn't be tried in military courts, does this mean that those people could be tried again in military courts now that this bill is going to be signed into law?
Ideally, it's not possible. It would be unconstitutional. A person cannot be charged with the same offense twice. So where Dr. Besigye and Obed are in civil court, it's impossible to transfer that file. But like I underscored, that this is a political tool for repression. So it wouldn't be surprising if President Museveni and his party can reenact repealed sections of court in violation of the Constitution and in contempt of the Supreme Court. They can do all other crazy things to settle political scores.
A constitution is, in most cases, a working document. It can be amended anytime, depending on what the country thinks. In most cases, they adjust it or rewrite it to make it make it current. In this case, the government is arguing that maybe it needed an overhaul. Some sections of the law needed an overhaul. That's why they went to Parliament. They're doing it legally. So, in terms of what they have done, the process they have go through Parliament, makes it a legal process. Now, from where you stand, what does this mean?
The purpose of the law captured under the object of the law, which includes trial of civilians in court martial, is a contempt of the Supreme Court decision, but also a violation of Article 92 of our Constitution. So going to Parliament for rubber stamping does not make the law legal or constitutional or legitimate for that matter. So Parliament can act as a rubber stamp because it violated procedures for legislation by closing out members of the public like ourselves who had submitted a memorandum and were never invited to the committee, as well as the other stakeholders. So when you close out public participation, you are also a mere rubber stamp because you are not following legislative principles. Legislative principles must respect the Constitution, must include public participation, and must also take care of the other laws of the country. It never did the three. So we can't say that because it is Parliament that endorsed the law, therefore it's constitutional and legitimate. It is not.
Well, Dr. Sarah Birete, we'll leave it there. Thank you so much for your time.
Dr. Sarah Birete is a Ugandan lawyer, founding partner, and executive director for the Center for Constitutional Governance, a Ugandan constitutional watchdog. And hey, we want to hear your thoughts on this topic. Drop us a comment below. What do you think about this controversial bill that gives military courts the power to try civilians? Don't forget to like, follow, and subscribe to Paul Ndiho on X, Instagram, Threads, LinkedIn, Blue Sky, and YouTube.